الجامعة الإفتراضية السورية كتاب كريمنال لو القانون الجزائي باي عماد الدين محمد الوحدة التعليمية الرابعة Chapter 4 يغطي هذا التسجيل الشرائح من 23 وحتى النهاية. تقدمت مبادرة ضوء بصوت دانة بيرقدار. Slide 23 Reform. In November 2006, the Law Commission published their report, Murder, Manslaughter, and Infanticide, Law.com. number 304. In this report, the Law Commission reviewed the law relating to homicide and made major recommendations to reform the current system. The Law Commission recommended replacing the current two-tier structure of murder and manslaughter with a new three-tier structure of general homicide offenses. 1. First-degree murder. 2. Second-degree murder. 3. Manslaughter. The report states at paragraph 2.4 that to bring greater order, fairness, and clarity to the law of homicide, the scope of and distinction between individual homicide offenses must be made clearer and more intelligible, as well as being morally more defensible. Slide 24. First-degree murder. This carries a mandatory life sentence in prison, and it would be committed where the defendant 1. Kills intentionally, or 2. Kills with an intention to do serious injury coupled with an awareness of a serious risk of causing death. The mens rea of this offense requires the prosecution to prove either that the defendant intended to kill or that he intended to cause serious injury. If it is proved that he intended to cause serious injury, this is an additional requirement that the defendant recognized that there was a serious risk of causing death by his action. If the defendant is not aware of a serious risk of causing death, he will not be liable for first-degree murder but will be liable for second-degree murder. Slide 25. Second-degree murder. The maximum sentence is a discretionary life sentence. This offense would be committed where the defendant 1. Kills and intends to do serious injury, or 2. Kills with an intention to cause some injury or a fear or risk of injury and was aware of a serious risk of causing death, or 3. Kills and there is a partial defense to what would otherwise be first-degree murder. Slide 26. Second-degree murder. The offense of second-degree murder is a lesser offense than first-degree murder. It is much wider than the current offense of murder. It can be committed where the defendant kills and intends to do serious injury. There is no need to prove that the defendant was aware of a serious risk of causing death. It can alternatively be committed where the defendant kills and intends to cause either some injury or a fear or risk of injury. It must also be proved that the defendant was aware of a serious risk of causing death. The final way in which second-degree murder can be committed is where the defendant kills and has a partial defense. Slide 27. Manslaughter. The maximum sentence is a discretionary life sentence. This offense would be committed where the defendant 1. Kills through gross negligence as to a risk of causing death, or 2. Kills through a criminal act, A. Intended to cause injury, or B. Where there was awareness that the act involved a serious risk of causing injury. 3. Participates in a joint criminal venture in the course of which another participant commits first or second-degree murder in circumstances where it should have been obvious that first or second-degree murder might be committed by another participant. Slide 28. Manslaughter. Manslaughter is a lesser offense than second-degree murder. This offense encompasses forms of gross negligence manslaughter and unlawful act manslaughter. It also encompasses liability on the basis of a joint venture, where the perpetrator commits first or second degree murder, and it should have been obvious that first or second degree murder might be committed. Slide 29, voluntary manslaughter. It is important to distinguish between the two different types of manslaughter, voluntary manslaughter and involuntary manslaughter. An easy and simple way to do this is to determine whether a scenario is one of voluntary or involuntary manslaughter, is to look for an intention to kill or cause GBH, the mens rea of murder. If mens rea is present and the defendant is able to plead a special defense, his liability may be reduced to voluntary manslaughter. If the mens rea is absent, the different types of involuntary manslaughter require discussion. If the defendant charged with murder successfully pleads one of the three special partial defenses, loss of control, diminished responsibility, or suicide pact, he will be acquitted of murder and convicted of manslaughter. This type of manslaughter is known as voluntary manslaughter. In these cases, the defendant accepts that he did cause the victim's death and that he intended to kill or cause GBH, actus reus and mens rea of murder. Slide 30. Loss of control. Loss of control is a partial defense to murder under Section 54 of the Coroners and Justice Act 2009 and is a new defense replacing the old common law defense of provocation. Loss of control is a special defense and may only provide a defense of murder. It is not a general defense and will not absolve liability for any other offense. The defendant who pleads loss of control successfully will be absolved of liability for murder but still be convicted of manslaughter. Evidential issues. The legal burden of disproving loss of control remains with the prosecution. The defense bear an evidential burden to raise some evidence of loss of control. See the case of Acott 1997, 1 WLR 306. Slide 31. Elements of loss of control. Section 54 of the Coroners and Justice Act 2009 gives three main elements. 1. The defendant must lose self-control. 2. The loss of control must have a qualifying trigger. And 3. A person of the defendant's sex and age with a normal degree of tolerance and self-restraint and in the circumstances of the defendant might have reacted in the same or a similar way as the defendant did. Defendant's loss of control is subjectively assessed and the defendant himself must have actually lost self-control. It is not enough that reasonable man would have lost control but the defendant actually did not. Slide 32. Elements of loss of control. للإطلاع. There is no requirement that the loss of control be sudden. This new position under Section 54, Number 2 of the Coroners and Justice Act 2009 is in direct contrast to the old common law which required a sudden and temporary loss of control. See the case of Duffy, 1949. The defense of loss of control will not apply if, in doing or being partly to the killing, the defendant acted in a desire for revenge. Circumstances which include a desire for revenge are inconsistent with provocation, since the conscious formulation of a desire for revenge means that a person has had time to think, to reflect, and that would negative a sudden temporary loss of self-control, which is of the essence of provocation. Lord Devlin in the case of Duffy 1949. This was confirmed in the case of Abrams and Gregory 1981, 74 CR APPR 154. Slide 33. Elements of loss of control. للإطلاع. One criticism of the Coroners and Justice Act 2009 is that there is no guidance as to the meaning of what degree of consideration will preclude the application of defense. Professor Ormerod questions whether arming oneself with a weapon, as in the case of Pearson 1992 CRIMLR, CRIM LR 193, would be regarded as a considered desire for revenge and thus preclude the operation of the defense. This question will be left to be determined by the jury. Students may want to read the case of Ahluwalia 1993-96 CR APPR 133, as this is the leading authority on cooling off periods under the old common law and the problems it raised. Slide 34. Qualifying trigger. للاطلاع يوجد صورتين، الأولى لوجه خائف afraid والثانية لوجه غاضب angry. Another new addition to the law is the requirement of a qualifying trigger under Section 54(1)(b) of the Coroners and Justice Act 2009. This requires that the loss of control was the result of two qualifying triggers. 1. Fear trigger, based on the defendant's fear of serious violence, and 2. Anger trigger, based on something which is said or done which amounted to circumstances of an extremely grave character which caused the defendant to have a justifiable sense of having been seriously wronged. Slide 35. Sexual infidelity. للاطلاع. A conversational addition to the law, Section 55(6)(b) of the Coroners and Justice Act 2009, which stated that the fact that a thing done or said constituted sexual infidelity is to be disregarded and will not be a qualifying trigger. The defense of loss of control will not be available to a defendant who kills as a result of a loss of control triggered by the discovery that his partner has been unfaithful. Slide 36. Reaction of a person of normal tolerance and self-restraint. للاطلاع. The defendant's reaction is to be compared to that of a person with a normal degree of tolerance and self-restraint, sharing the age and sex of the defendant, Section 54(1)(c) of the Coroners and Justice Act 2009. This follows the approach taken in the case of Camplin 1978, AC 705, and Attorney General for Jersey v. Hawley 2005, UK PC 23, before the implementation of the Coroners and Justice Act 2009. Professor Norrie questions the role that sex should play in the new law and also criticizes the use of age. Norrie 2010, 281. Slide 37. Control characteristics and gravity characteristics. للاطلاع. In the case of Camplin 1978, Lord Diplock made a distinction between characteristics which affect the level of self-control to be expected of the defendant, control characteristics, and characteristics which affect the gravity of the provocation to the defendant, gravity characteristics. After Camplin, the age and the sex of the defendant were the only control characteristics which could be taken into account, and there was no limit on the gravity characteristics which might be considered relevant. See the cases of Humphreys 1995 for all ER 2008, Dryden 1995 for all ER 987, Thornton number 2 1996 to all ER 1023, Morehall 1996 AC 90 LUC 1 VR 1997 AC 131. يوجد جدول من عمودين، العمود الأول Control Characteristic والعمود الثاني Gravity Characteristics. Control Characteristics. Number 1. Characteristics which affect the level of self-control to be expected of the defendant. Number 2. Only age and sex can be taken into account. See Kaplan 1978. العمود الثاني Gravity Characteristics. 1. Characteristics which affect the gravity of the provocation to the defendant. 2. Any characteristic can be taken into account. Slide 38. Diminished responsibility. The defense of diminished responsibility was introduced by the Homicide Act 1958 as a result of criticism of the defense of insanity. Diminished responsibility differs to insanity in that it is a special defense available in relation to murder only and is not a defense to attempted murder. See the case of Campbell 1997, Crim LR 495. By contrast, insanity is a defense to any offense. Diminished responsibility is also a partial defense, so a successful plea of diminished responsibility will reduce the defendant's liability to manslaughter. Slide 39. Diminished responsibility, evidential issues. The legal burden of providing diminished responsibility is on the defendant, as with insanity, Section 2.2 of the Homicide Act 1957. The defense must prove all of the elements of diminished responsibility on a balance of probabilities. See the case of Dunbar 1958 1QB1. In the case of Lambert, Ali and Jordan 2001 2WLR 211, the Court of Appeal confirmed that placing the legal burden of providing diminished responsibility on the defendant did not violate the presumption of innocence under Article 6.2 of the European Convention on Human Rights, because diminished responsibility is a defense and does not form part of the elements of the offense of murder. Slide 40. The elements of diminished responsibility. 1. A person who kills or is a party to the killing of another is not to be convicted of murder if D was suffering from an abnormality of mental functioning which A. aroused from a recognized medical condition, B. substantially impaired D's ability to do one or more of the things mentioned in subsection 1A, and C. provides an explanation for these acts and omissions in doing or being a party to the killing. 1A. Those things are A. to understand the nature of D's conduct, B. to form a rational judgment, C. to exercise self-control. 1B. For the purposes of subsection 1C, an abnormality of mental functioning provides an explanation for D's conduct if it causes or is a significant contributory factor in causing D to carry out that conduct. Slide 41. Elements of diminished responsibility. للاطلاع. The defendant's abnormality of mental functioning must arise from a recognized medical condition, and it must substantially impair the defendant's ability to understand the nature of his conduct, from a rational judgment or exercise self-control, and must provide an explanation for the defendant's conduct. The defense must prove that the defendant 1. was suffering from an abnormality of mental functioning, 2. arising from a recognized medical condition, 3. which substantially impaired the defendant's ability to understand the nature of his conduct, form a rational judgment, or exercise self-control, and 4. which provides an explanation for the defendant's acts and omissions in doing or being party to the killing. Slide 42. abnormality of mental functioning للاطلاع. This must be proved by the defendant that they were suffering from an abnormality of mental functioning at the time of the killing, prior to the amendments made by Section 52 of the Coroners and Justice Act 2009. This was known as an abnormality of mind, and the leading authority in the case of Byron 1960 2QB 396. In this case, Lord Parker CJ stated that abnormality of mind means a state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. It appears wide enough to cover the mind's activities in all its aspects, not only the perception of physical acts and matters, and the ability to form a rational judgment as to whether an act is right or wrong, but also the ability to exercise willpower to control physical acts in accordance with that rational judgment. هناك 3 دوائر تحتوي understanding of conduct, ability to make rational decision, and ability to exercise control. Slide 43. Abnormality of mental functioning للاطلاع. So this definition was very wide as it covers both the defendant's brain and all aspects of the mind's activities. By contrast, the term disease of the mind is very narrow. This was an element of the defense of insanity under the M. Norton Rules 1843. The spelling is M'*NAGHTEN Rules 1843. It is a requirement of insanity that the defendant did not know what he was doing. However, the defendant in Byron would not have been able to successfully plead insanity as he did know what he was doing was wrong, but he failed to control his impulses. These are not requirements of diminished responsibility, although a defendant may plead diminished responsibility even though he knew what he was doing. The defense of diminished responsibility is much wider than the defense of insanity and does not require a defendant to be insane or partially insane. So diminished responsibility and insanity must remain distinct defenses. Students may wish to read the case of Sears 1984-79 CR-APPR 261. Slide 44. Recognized medical condition للاطلاع. The abnormality of mental functioning must arise from a recognized medical condition and must be supported by medical evidence. See case of DIX or DIX 1981-74 CR-APPR 306. Prior to the amendments of the Coroners and Justice Act 2009, the causes from which the abnormality of mind arose were widely construed. See the cases of Hobson 1981, 1 CR-APPR 31, Battered Women's Syndrome, Ahluwalia 1993, 96 CR-APPR 133, Depression, Smith 1982, Crim LR 531, Premenstrual Syndrome, Vingager 1979, 69 CR-APPR 104, Morbid Jealousy or Sanderson 1994, 98 CR-APPR 325, mental and physical illness. However, now any recognized medical condition which causes an abnormality of mental function is sufficient. Slide 45. Substantial impairment of the defendant's ability للاطلاع. The defendant must also prove that the abnormality of mental functioning substantially impaired his ability to do one of the things listed in subsection 1A of the Coroners and Justice Act 2009. 1. Understand the nature of his conduct. 2. Form a rational judgment. 3. Exercise self-control. It also must prove an explanation for the defendant's acts and omissions in killing or being a party to the killing, and involves consideration of the extent to which the defendant is answerable for his acts according to his state of mind and ability to exercise self-control. Whether or not the defendant's ability to do one of the things listed was substantially impaired is a question for the jury to determine. See the case of Lloyd, 1967, 1 QB 175. Slide 46. Diminished responsibility and intoxication. للاطلاع. One issue which remains to be addressed is the effect of intoxication on the defense of diminished responsibility. In the case of Fenton, 1975, 61 CR-APPR 261, the Court of Appeal held that self-induced intoxication cannot produce an abnormality of mind as it was then for the purposes of Section 2.1 of the Homicide Act 1957. Intoxication alone may not amount to one of the inherent causes under Section 2.1 of the Homicide Act 1957. However, a condition such as alcoholism may amount to an abnormality of mental functioning, as it is a recognized medical condition. See the case of Tandy, 1989, 1 WLR 350. Slide 47. Alcohol dependency syndrome. للاطلاع. For alcoholism to amount to an abnormality of mind, the defendant's craving must render his consumption of alcohol involuntary. Where the defendant's consumption of alcohol was voluntary, but he did not resist an impulse to drink, the defense of diminished responsibility would not be available. However, in the recent case of Woods, 2008, 2 CR-APPR 34, the Court of Appeal held that alcoholism could be regarded as an abnormality of mind for the purposes of diminished responsibility, even where there had been no brain damage resulting from the alcohol dependency syndrome. The Court of Appeal held that it was no longer appropriate to make a distinction between cases where brain damage had or had not occurred. Even if the defendant voluntarily consumed alcohol, he may still rely on the defense of diminished responsibility, according to the case of Stewart, 2009, 2 CR-APPR 30. Whether alcoholism would amount to an abnormality of mind would be a matter for the jury and would depend on the nature and extent of the alcohol dependency syndrome and whether the defendant had an irresistible craving to drink. Slide 48. Multiple causes للاطلاع. Recent case law has explored the effect of intoxication on the defense where the defendant is suffering from an abnormality of mind caused by an inherent cause and is also intoxicated at the time of the killing. In such cases, the jury must be directed to disregard the defendant's intoxication. If the jury is satisfied that, despite the intoxication, the abnormality did substantially impair the defendant's mental responsibility for his acts, the defense of diminished responsibility will be successful. See the case of Gittins, 1984. QB 698. The defendant killed his wife and stepdaughter. His abnormality of mind had been caused partly by his depression and partly by his consumption of alcohol and medication for his depression. Also see the case of Dietskman, 2003, UKHL 10. Thus, where a defendant is intoxicated and suffering from abnormality of mind, mental functioning, the jury must ask whether, despite the drink, the abnormality of mind substantially impaired the defendant's responsibility for the killing. Slide 49. Suicide pact. Suicide pact is also a special defense, available only to murder. It is a partial defense like loss of control and diminished responsibility, which reduces liability to manslaughter if pleaded successfully. A suicide pact arises where two or more people agree to kill each other. If one of the parties to the suicide pact survives, he may be charged with murder and may have the defense available to him. If he successfully pleads suicide pact, he will be convicted of manslaughter. Evidential issues. The legal burden of proving that the defendant was acting under a suicide pact with the victim resists with the defense under Section 4.2 of the Homicide Act 1957. The standard of proof is on a balance of probabilities. Slide 50. The elements of suicide pact. للإطلاع. The defense of suicide pact is provided for under Section 4.1 of the Homicide Act 1957, which states that it shall be manslaughter and shall not be murder for a person acting in pursuance of a suicide pact between him and another to kill the other or be a party to the other being killed by a third person. The term suicide pact is explained under Section 4.3 of the Homicide Act 1957. It requires all persons who are party to the suicide pact to have a common agreement which has as its objective the death of all parties to the suicide pact. Only acts committed while the defendant has a settled intention of dying may be treated as acts done in pursuance of the suicide pact. Slide 51. Encouraging or assisting suicide. للإطلاع. It is no longer an offense to commit suicide as it was abolished by Section 1 of the Suicide Act 1961, but it is an offense to encourage or assist suicide or encourage or assist attempted suicide under Section 2.1 of the Suicide Act 1961, as amended by Section 59 of the Coroners and Justice Act 2009. If a defendant helps or encourages another person to kill themselves, he may be charged with this offense instead. This offense carries a maximum sentence of 14 years imprisonment. See the case of R on the application of Purdy v. DPP 2009 UKHL 45. Students may also wish to read the finalized policy online at هناك رابط http://www.cps.gov.uk/publications/assisted_policy.html. Please note that the language used in the amendments corresponds to the offenses of encouraging or assisting the commission of offenses under sections from 44 to 46 of the Serious Crime Act 2007. Slide 52. Infanticide. Under Section 1.1 of the Infanticide Act 1938, infanticide arises where a woman kills her child, who is under 12 months of age, by any willful act or omission, and at the time the balance of her mind was disturbed due to the birth. A woman may be tried for the offense of infanticide or may be tried for murder and raise the defense of infanticide under Section 1.2 of the Infanticide Act 1938. Infanticide is treated like a conviction for manslaughter and carries a maximum penalty of life imprisonment. The defendant bears an evidential burden, but the prosecution bears the legal burden of proving that infanticide does not apply. Slide 53. Summary. للإطلاع. Murder is a common law offense and is committed when a defendant unlawfully causes the death of a person with the intention to kill or cause GBH. There are two types of manslaughter: voluntary manslaughter and involuntary manslaughter. where a defendant has both the actus reus and the mens rea for murder, but also has one of the special partial defenses available to him, his liability for murder is reduced to that of manslaughter, voluntary manslaughter. Loss of control is a statutory defense under Section 54 of the Coroners and Justice Act 2009 and is a defense to murder only. A successful plea of loss of control will reduce the defendant's liability to voluntary manslaughter. Slide 54. Summary للإطلاع. There are three elements to the defense of loss of control. 1. The defendant loses self-control, which is the subjective test. 2. The loss of control had a qualifying trigger. And 3. A person of the defendant's sex and age with a normal degree of tolerance and self-restraint, and in the circumstances of the defendant, might have reacted in the same or in a similar way, which is the objective test. Diminished responsibility is a defense under Section 2 of the Homicide Act 1957, and it is a defense to murder only. A successful plea of diminished responsibility will reduce the defendant's liability to voluntary manslaughter. There are three elements to the defense of diminished responsibility. 1. The defendant must suffer an abnormality of mental functioning. 2. Which arises from a recognized medical condition. And 3. Which substantially impairs the defendant's ability to understand the nature of his conduct, form a rational judgment, or exercise self-control, and which explains the defendant's acts and omission in doing the killing. Slide 55. Self-test questions. 1. Define murder. 2. What is the mens rea for murder? Cite an authority for this. 3. Explain the difference between voluntary manslaughter and involuntary manslaughter. 4. What is the subjective element of the defense of loss of control? 5. Explain what a qualifying trigger is. 6. Explain the difference between gravity characteristics and control characteristics. 7. Can any of the defendant's characteristics be taken into account in relation to the last element of control? 8. What are the elements of diminished responsibility? 9. Who bears the legal burden for 1. Loss of control, 2. Diminished responsibility, 3. Suicide pact. 10. What are the requirements for the defense of suicide pact? Students may wish to visit the online resources for suggested approaches. هناك رابط http://www.oxfordtextbooks.co.uk/orc/monaghan2e/ نهاية التسجيل ونهاية Chapter 4 من الشرائح 23 وحتى النهاية.